Please, start the court now in session. The Honorable Judge Karen Ketchum presiding. Please be seated.
We have the attorney's list.
Yes.
Good morning. Thank you. Mr. Rare? We're not here. Not here. Ms. Merrifield?
Good morning, Your Honor.
Good morning.
I have inmate Blackburn. Brandy Merrifield on behalf of Chad Blackburn. This is 24 CF 1261. Mr. Blackburn is present. Judge, we're here today on a motion to reduce bond that was filed on June the 11th. I have had the benefit of speaking with Ms. Bossow since filing that motion, and we have come to an agreed bond, but I would like to give the court just a little bit of information because there's some disparity. When he was arrested, he was charged with 35 charges, but the first appearance judge only found probable cause for 8. So there was bonds placed on 8 of those charges, although he has the 35. So the total bond right now is $650,000. The state and I have discussed bonds to establish for each individual charge, and that would be for counts 1 through 30. It would be $2,500 cash or professional for a total of $75,000 cash or professional. Counts 31 through 34 is 5,000 signature for a total of 20,000 signature, and then count 35, 2,500 signature. There are some other pretrial
So
conditions.
31 through 35 would be signatures?
Yes, sir, Your Honor.
Okay.
So it would be a monetary bond on 1 through 30 in accordance with the bond criteria schedule, the suggested schedule. The first appearance judge also ordered pretrial services and a number of conditions based on the offenses, so weekly reporting in person, no contact with any minors, no internet access or internet-capable device, not be in a place where minors congregate, no possession or ownership of any animals, and the state is also requesting, which we have no objection to, a GPS monitor being attached before release at the rate of $1 a day.
And Your Honor, with those safeguards in place, the state is comfortable with the proposed amount of bond, and we have no objection to it.
Okay, so we're basically keeping all the pretrial services requirements in that are currently in.
But we are adding the
And you're
GPS.
adding GPS.
Yes, sir.
And it's to be no contact with minors as opposed to, I believe it was originally no unsupervised contact with minors. We prefer it to be.
Okay, so there's 2 changes. We just
Yes,
want
sir.
to be clear so that,
Yes, sir.
got
Yes.
to make sure it on the record. So we're going to get an order on that?
I do have a proposed order that I can give to you now, or I can file an e-file, whatever the court prefers.
That's fine. If you've got it and it's been agreed to by the state, then let's go ahead and just do it.
Yes, Your Honor, there were the 2 changes that we already discussed, and we went ahead and initialed those off.
Very good.
If I may.
So based on the stipulation, the court will grant the modification of bond as set forth in the statement and in the order itself and agreed upon by the state.
Thank you, Judge.
Thank
That's
you
all I
very
have this
much.
morning.
Thank you very much. Mr. Durrell?
Morning, Your Honor.
Good morning.
Your Honor, my first client today is Mr. Alejandro Del Toro Ortega. Your Honor, we do have a written plea in this matter. I've gone over it with Mr. Del Toro Ortega. He still needs to sign it, however.
Okay.
This is exactly what we just talked about. You're all good. You sign right now. If I may approach, Your Honor?
Thank you. Would you announce the terms?
Yes, Your Honor. In cases 2023 CF 2377 and 2024 CF 0834, Mr. Del Toro Ortega will admit the violation of probation, the understanding that probation will be modified to 2 years community control, followed by 1 year of drug offender probation. Both cases concurrent. Well, actually, all cases are going to be concurrent, Your Honor. In case 2024 CF 1392, count 1 will be 2 years community control, followed by 1 year drug offender probation. Count 2 will be 1 year of community control. Again, all counts and cases are concurrent with each other. This is an adjudication of guilt.
And Your Honor, that is the state's agreement. Mr. Del Toro Ortega's scores a total sentence points of 41.8 since it's not a downward departure. And I do have a score sheet that I'll give to the court, I believe.
Very good. Mr. Ortega, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and those same terms are in writing that you've signed.
Yes, sir.
Have you read this closely and gone over it in detail with your attorney?
Yes, sir.
You believe you have had all your legal questions answered?
Yes, sir.
Importantly, by entering into this agreement here today, you're waiving the right to go to a final, an evidentiary hearing to force the state to prove their case. This will be a final resolution of these cases here before us today. Do
Yes,
you
sir.
understand that?
Yes, sir.
Okay. And you believe this is in your best interest and you're entering this freely and voluntarily?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. And as to 23 CF 2377 and 24 CF 834, there'll be an admission of the violation, 2 years community control, followed by 1 year of drug offender probation on both counts. They'll be served at the same time or concurrently. And in 24 CF 1392, it's 2 years of community control. So again, same thing, followed by 1 year of drug offender probation. And count 2 is 1 year of community control. All counts concurrent. Okay? So make sure you check in with probation as soon as you get out today. Okay?
Okay, thank you.
Okay, thank you.
My next client today is Ms. Catherine Garstein. Okay, this is everything we just went over. If you're good with everything, you sign right there. If I may approach, Your Honor?
You may. Thank you. Would you announce the terms, please?
Yes, Your Honor. Your Honor, at this time, Ms. Garstein, in case 2023 CF 1757, will admit the violation with the understanding that probation would be modified for the remainder of the probationary term to drug offender probation. In case 2024 CF 1316, she will plead no contest as charged with the understanding that count 1 will be fines and costs in the amount of $615, $100 cost of prosecution, 1 year drug offender probation, count 2 is time served, all cases and counts concurrent to each other. This is a withhold of adjudication, Your Honor.
That is the state's agreement, Your Honor.
Okay, Ms. Gerhardson, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of your plea. Put your hand down. You heard the terms of the plea agreement that your attorney stated, and those are contained in your written plea agreement that you've signed. So I just want to make sure, have you gone over it in detail with your attorney?
Yes, sir.
Gone over and asked all your legal questions? Understand that by entering into this, this will be a final resolution of this matter.
Yes.
You're waiving the right to go to a trial, to go to a final hearing on these, to force the state to prove their case. You're waiving that, so you get this final resolution here today. Is that what you want to do?
Yes, sir.
Are you entering this freely and voluntarily? Nobody's twisting your arm to get you to enter into this, are they?
Yes.
Okay. Very good. Based upon that testimony, the court will accept your plea. And as to 23 CF 1757, will be an admission of the violation, and the court will modify, basically, the term of the probationary period will remain the same, but it'll be modified to drug offender probation rather than regular probation. In 24 CF 1316, count 1, which is possession of controlled substance, you'll have 1 year of probation and then all the standard court costs. And as to count 2, which is the possession of paraphernalia, the sentence will essentially be time served. Okay? And these, the 1 year probation, I'm assuming, is concurrent with the 23 CF 1757.
Yes, Your Honor.
State's in agreement with all that?
Yes, Your Honor, the state is in
Okay.
agreement.
Any questions, ma'am? Make sure and stay in good contact with probation now. This will be additional requirements with this drug offender. You violate again, you know. Okay? Thank you.
That's all I have for today, Your Honor.
Thank you, Mr. Durrell. Yes, sir.
Thank you.
Mr. Kilpatrick?
Good morning, Your Honor. Keith Kilpatrick, representing Johanna Dwyer, case number 22 CF 2711. She is present in the courtroom as she approaches the lectern. We filed a motion in this case to convert her current community control to probation.
The court has reviewed the motion. What's the state's position?
Your Honor, the state and the victim do object to her being released from community control early. Your Honor, this was a very serious robbery case. The defendant and the state bargained for 1 year of community control. She is lacking about 5 months of community control. I do understand that she has had no community control violations, and she would like to be released early to be allowed to travel to Georgia, Your Honor, but she bargained for a year on a very serious case, and the state and the victim would ask the court not to remove requirements that she bargained to complete, Your Honor.
Mr. Kilpatrick?
And Judge, I would actually call Ms. Dwyer as a witness.
Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, I swear.
Okay. Please state your name for the record.
Johanna Dwyer.
Okay, we filed a motion to modify your current community control, which is house arrest, to regular probation, which is a different type of supervision. Is that correct?
Yes.
Okay. And you've been on there roughly over 6 months. Is that correct?
Yes.
Has there been any violations?
No, sir.
Okay. Have you completed all the requirements that were requested of you within that period of time?
Yes, all the
Okay.
requirements from the,
Okay. So you've paid all your court costs, is that correct?
yes.
Have you done all your community service work completed, is that
Yeah.
correct?
Yes.
All right. Since then, have you been tested for any controlled substances while on community control?
Yes.
Given breath tests?
Yes.
Have you violated anything?
No, sir.
You were actually on pretrial release, which was on for roughly 2 years, is that correct?
Yes.
During pretrial release, you were tested and breath tested during that period of time, is that correct?
Yes.
And that was every month, is that right?
Yes.
Did you ever test positive for any controlled substance or alcohol use during that period of time?
No, sir.
Okay. You have a son, is that correct? How is your youngest son?
He's 22 months.
Okay. And does he suffer right now from learning disabilities?
Yes. Still.
Okay. Are you required to go to several doctor's appointments for potential autism and hearing disability?
Yes.
Okay. Does this require you sometimes to leave the county to do this?
It does require that.
Okay. You also have other children.
I do. I have 2.
Okay. And what are their respective names or
It's-
first name and their ages?
Brianna Chanel Green and Jamie and Delani Green, and their ages are 11 and 10.
Okay. Where do they reside?
They reside in Brunswick, Georgia at this time with my parents.
Okay. And is there a DCF case plan up there in Georgia?
Waiting for me to get done with this. Yes.
Correct. And Have you been able to travel to Georgia?
I have not on CC, but I was. On pretrial, they did let me see my children.
Okay, but since you entered to community control, since then, you've asked for permission?
I have not asked for permission. I'm not allowed to leave my house, but I haven't seen my children for 7 months.
Okay. And is it your goal to actually move it to Georgia eventually and have contact and work that case plan?
Yes. If my CC was discontinued, I would move to Georgia.
Okay. And do you rent right now?
Yes.
Who do you live with?
I live with my husband and my son,
Okay. Your youngest son?
my baby son, yeah.
Okay. And they're present in the courtroom, is that correct?
Yes.
Okay. And now, when does your lease end?
My lease ends whenever I'm off CC. They've made it to month to
Okay.
month until I get off here.
Okay. All
I
right.
also did I also did the.
What else, what are the anti-theft class you've done?
Yes.
You successfully completed that as well?
Yes.
So you've done all your requirements of community control, and you did that even though you were on 1 year of community control followed by several years, 9 years of probation, is that right?
Yes.
Okay, but you did all of those requirements and your court costs within them.
Yes, sir.
And you're paying the cost of supervision, is that correct?
Yes, it's up to date.
It is up to date. And I have no further questions from my client, Judge.
State.
Your Honor, the state has nothing to add.
Have you not been able to attend your youngest child's appointments?
I have not been able to, sir,
Why?
because the appointment is actually in Mariana, and I'm on CC, and Mariana is kind of far. It's,
Have
It's a
you
hearing.
requested that?
I have requested it.
And they won't allow it?
I'm not, well, I'm on CC, so I'm
I
just not allowed to.
I understand you're on
Okay.
CC, I get that. But there are accommodations too. I
Okay.
mean, they're denying your,
Yeah, there's a few different things that I have been denied with my son, so, it's not just that. He has autism, anyways, I'm not gonna get into his health, but anyways, he is delayed, and I'm just gonna pick up where I left off. I'm not gonna have an attitude. Whatever y'all decide, I'm sorry
okay,
for
it's all right.
everything that I've done. you
Sorry.
know.
So basically, the judge is asking you, you've requested, you've been denied,
Yeah.
and their reason why they denied you, did they tell you orally
The reason why I was denied is because it was out of state,
or out of county?
out of county. It was out of county. It's in Mariana, Florida, but it was out of county.
So your husband had to take the child?
He did not take it. He did not.
Oh, the child missed the appointment?
He did. He did.
does probation have any input on this?
Sir?
Yeah, I'm not on probation here.
You're not on probation here?
No, she's saying she's on community control.
That's the type of probation, go ahead.
I can't confirm all the things he said about, I can't confirm all the things he said about what he's done, that is true. I don't understand why the officers weren't allowing her to travel. I don't understand.
I'm asking the same question, so you
I
know.
mean, she's not on GPS, so that's not an issue, so I personally would allow my offender to travel to Mariana for a doctor's appointment. That's the only specialist in the area that can handle that, but I'm not understanding why the other officer didn't.
Okay. Ms. Sharpless, you have some question?
Your Honor, is she, I don't think is she being supervised on CC? You're not being supervised in CC on this county, are you?
No, she's not at the Tallahassee office.
She's being supervised out of another circuit, Your Honor, so that's, the community control officer is supervising her, is not one of our community control officers. I think that's what Officer Howell
So
is trying to
you
explain.
live in Tallahassee?
I live in Parker, Florida.
Where's Parker, Florida?
It's about an hour and 43 minutes from here. And it's Bay County.
It's Bay County, okay.
They basically just wants me to know that I can't do anything that I wouldn't do if I was in prison. If I can do it in prison, I cannot do it, and that's what is said to me every time I go. Don't think that, and
So you're being supervised, you live in Bay County, you're being supervised in community control by an officer in Leon County?
in Bay
Bay County.
Bay County,
Bay County.
Bay County, I'm sorry.
Okay, okay. I was totally confused there.
But you're not asking to get
So
off,
Bay County,
you're not asking to get off of any type of supervision, is that correct?
I'm not.
Yeah, you're just wanting to convert the remaining amount to just regular.
no, I understand what she's asking. I was asking the same question that our local probation officer just asked. I don't know, I believe we would, that doesn't make sense that you wouldn't be able to be allowed. And it sounds like you haven't even tried to be able to visit your older children.
I have not tried, you're right. I've been trying to focus on taking this one to the doctor. Sorry.
Okay.
She showed substantial compliance with the 2 years of pretrial release. She was on, has done exceptionally well by completing and paying all her court costs, doing her 50 hours community service work, and doing her anti-theft. She literally is only paying supervision fees.
State?
Your Honor, the state doesn't have any more argument that hasn't already been laid out to the court.
How many more months are we talking about?
5 more months, Your Honor, that she would have to complete. Judge, I don't know if this is relevant or not, but I did speak with the community officer before she moved to the Bay County area, and Mr. Ryan Flaherty actually said that she was an exceptional probation or community control person. So that's a proffer from an officer of the court, from me,
Okay.
as being an officer of the
Proffering hearsay evidence.
court. That is true, Your Honor.
Okay. Well, I appreciate it. I mean, it's. I mean, I've got questions that are not being answered here, so I'm going to grant it. I'm going to grant the request.
Thank you so much, Judge. I'll provide the court with an order.
So just remain on probation. All we're doing is changing from community control to regular supervision, which is what she would have been on anyway.
Yes, sir.
I mean, which is what she's going to be on for the remainder of her time, correct?
That is correct, Your Honor. That's all we're asking.
Okay.
And Judge, that's my last case. May I be excused?
You may. Thank you.
Thank you, sir.
Thank you, Your Honor.
And Mr. LaPella? You're waiting? Okay. Mr. Tony?
Your Honor, I think I'm waiting on you. Yes, maybe, okay. Good morning, Judge.
Good morning.
Your Honor, may I approach?
You may. Thank you. Would you announce the terms of the agreement?
Yes, Your Honor. Your Honor, Jeff Tony on behalf of the state of Florida versus David Flores. With regards to the pending case, 24 CF 882, which is domestic violence and tampering with a witness, pursuant to negotiations with the state attorney, we've agreed upon the following sentence to be imposed as a condition of this plea. Adjudication will be withheld as to count 1. Count 2, misdemeanor domestic violence, will be standard probation, 24 months, plus the cost of supervision, which is, court cost, which is $515. He shall have no violent contact with the victim, and 1129 shall be in the probation for the misdemeanor domestic violence.
That is the state's agreement, Your Honor.
Is there an adjudication as to count 2? It's not clear. It says withhold, adjudication withheld on count 1, but it's silent as to whether or not it's an adjudication or a withhold as to count 2, unless I'm missing something.
It would be my interpretation that the adjudication would be held as to count 2 as well.
It would be a withhold on both counts.
Yes, sir.
We need to put that in here. Is that in the state in agreement with that? Here you go, Mr. Tony.
Yes, Your Honor, state's in agreement.
Okay, just put that in there. That's obviously an important consideration for your client. Thank you. Thank you. So, as to count 1, I'm still a little unclear about count 1. So there's a withhold on just count 1. What's
The standard
the sentence?
probation is 24 months, as to count 1. Plus he's responsible for court costs. No violent contact with the victim.
So probation, 2 years of probation for
Yes.
each count,
Well, 1129 for the misdemeanor. Your Honor.
for the misdemeanor? Okay. Gotcha. I'm just trying to understand.
That's fine.
Okay. I'm not sure we're exactly clear on this. That's what I'm reading, to make sure that what you said is contained in this writing. I think I understand it, but make sure we can get it clear.
Yeah. I mean, with regards to count 1, there's 24 months of probation. He's responsible for court costs and any fees that's applicable with that, the PD fee, whatever. Also, he's had no violent contact with the victim. As regards to count 2, he's responsible for 11.
Well, no contact with the victim has to do with count 2, not count 1, I'm assuming. That's the battery, it's count 2.
Yeah,
So the no contact with the victim is to count 2.
No violent contact.
No violent contact.
Well, Your Honor, since it'll be the 2-year term on count 1, the no violent contact, it's the state's intention that that's put in place for the whole 24 months. And then the 1129 to run concurrent.
Correct.
For the count 2, for the DD
Correct.
battery.
Correct. Right.
Okay. Senor Flores, would you please raise your right hand? I need to ask you some questions. Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, you heard your attorney, I know there's some discussion, but you heard your attorney state the terms of your plea agreement that is also contained in the written plea agreement. Now, I know this plea agreement is in English, and Spanish is your first language. So I want to make sure you understand what's in the plea agreement. So have you had your plea agreement explained to you in detail?
Yes.
Yes, sir.
And have you been able to ask all your legal questions with your attorney?
Yes, sir.
And you understand that by entering into this agreement, this will be a final resolution of this case? You're not going to go to a trial or any further hearing as long as you abide by the terms of the probation?
Yes.
Yes, sir.
And you're entering into this freely and voluntarily?
Yes.
Do you have any questions concerning this agreement?
No.
Okay. Based upon that testimony, the court will accept the plea agreement. And as to count one, there'll be a withhold of adjudication, and the defendant will be sentenced to 2 years standard probation with standard fees and court costs. As to count two, there'll be a, which is domestic violence battery. The defendant will be sentenced to 11 months, 29 days probation to be served at the same time concurrent with the count one. Count two will also have a withhold of adjudication. And as a condition on both of these probationary counts, there will be no violent contact with the victim, Gonzalez Mendoza, plus you must complete the batter's intervention program as well.
Batter's intervention.
What did I say?
No, you're correct.
Did I say?
I didn't make that announcement, Your Honor, doing my.
Well, it's in here, so.
Yes, yes, complete that.
You've had the batter's intervention program explained to you?
No.
Just make sure he understands what it is. Okay. You clear about that?
Yes.
Are you in agreement? Okay. Make sure as soon as you get through here today, immediately go down to probation to sign in. Okay?
Mr. Tony, did you submit the score sheet?
Any questions?
No.
Your Honor, the state will be submitting the score sheet
Okay.
later on.
Very good. Thank
It's
you.
not
It's
a
not
downward-
it's not a downward departure.
It is not a downward departure, Your
Okay.
Honor.
Thank you. Thank you, Mr. Tony. Yes, sir. Ms. Dudley? Good morning.
The first one I have is Brown Camera Strong in 23 CF 1507. There's a waiver on file. The underlying basis of the violation was dismissed. So it's my understanding the state's going to dismiss the VOP and just reinstate probation.
That is the state's agreement, Your Honor. The state will dismiss the violation of probation.
So are you making that announcement on the record that that's what the state's doing, or are you going to do that, are we going to do that after today?
I'm going to make that on the record.
Okay, very good.
And he has
VOP
been
is
informed.
dismissed. I'm
He's been
sorry.
informed and he's already reported for probation.
Very good.
And the next case I have is Angela Johnson in 15 CF 2330 and 23 CF 1991. If I may approach.
May. Thank you. Could you announce the terms of the agreement?
Yes, sir. I've handed you a plea form for the violation of probation. It's my understanding the state is going to announce the dismissal in 23 CF 1991 on the record today. On the violation of probation, she would admit to the violation, adjudication of guilt, $100 VOP fee, 1129 in the county jail, with credit for time served, revoke and terminate probation, and all cost of judgment.
Your Honor, the state is announcing a no pros on 23 CF 1991.
Very good. And the state is in agreement, as stated by the defense, in 15 CF 2330?
That is correct, Your Honor.
Okay. Ms. Johnson, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard the terms of the plea agreement. One of your cases, 1991, is being dismissed. That's done today?
Yes.
The other one, 15 CF 2330, the plea agreement on the violation would be an adjudication of guilt and the other terms, 1129 in the county jail, et cetera. So have you gone over this agreement with your attorney? Make sure you understand all the legal ramifications.
Yes, sir.
And you understand that by entering this, you're waiving the right to go to a trial, force the state to prove their case. This will be a
Yes.
final resolution of this violation of probation.
Yes.
Okay, you believe this is in your best interest?
Yes.
And you have had all your legal questions answered by your attorney?
Yes.
Very good. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt of a $100 VOP fee. You're sentenced to 1129. In the county jail, you will get credit for all time served. You will revoke and terminate probation. When you get out, you're done with probation.
Okay.
And then the cost will go to judgment. Okay, any questions?
No.
Okay, thank you.
Thank you, Your Honor.
Thank you, Ms. Dudley.
Your Honor, that's all I have. Thank you.
You got it? Mr. Rare or who? Morning.
Your Honor, first I have this morning is Mr. Charles Abraham. His case number is 22 CF 1989. We filed a motion to recall KPS to set his BOP court date, do some scheduling there as he had previously. I was finally able to get up to the state today and speak about his case. My understanding is Ms. Charles does not object to recalling KPS and resetting his court date.
State?
That's correct, Your Honor.
Court will recall the KPS in 22 CF 1989.
And Madam Clerk, our next available BOP date we could set this for?
Sure. So we need a VOP date.
Correct.
Yes, Your Honor, this is a violation.
So August 15th, just a month from now, is that
I
work?
think that's fine, but we should be able to talk to the state if we down that.
August 15th, 9 a.m.
Perfect.
Okay.
You're good, sir. Thank you.
Sean LaPella for the record. There's one other matter that we have on the docket. It's listed as James Harden. If I may.
You may.
Your Honor, defense had filed a motion for rehearing on the request to depose the alleged child victim. The state filed a response asking the court not to grant such a motion, and the court entered a summarily directed order denying our motion before the hearing. However, I would
Before
ask
hearing?
the hearing that we have set for today.
Okay.
So I just want to put that down, that the court has summarily denied us without a hearing.
Well, that may not have been the court's intention.
Would the court allow us to, could we be indulged by maybe presenting a few issues of the case?
Well, what I would suggest is that we back up and withdraw that
Okay.
and have a hearing.
Okay.
But I'd rather not do it with our 5-minute slots here, because this is something that is a little more substantial, so.
If the court would like.
Because I would normally, this kind of thing would not be done without a hearing.
Certainly. I mean, we could submit a draft order recalling the prior order and setting a formal hearing, and we could schedule it with your JA for maybe an afternoon hearing docket.
Sure. That's generally what we would do.
Your Honor, the court presumptively signed the order denying the motion for rehearing because there had been no change in information, no change in circumstances. The court had before it all the information it required to make the original decision on whether or not deposition of the child would be allowed. And that is why the state objected to it, because there was no change. Much like a motion for rehearing on a bond, there's no substantial change in circumstances. There was no change here. There was no additional information, and therefore, it was not inappropriate.
That is heavily disputed.
So say that
heavily
again?
disputed.
Make your argument.
Your Honor, the state believes that the court was not in error in signing that without a hearing because there was previously a hearing held on whether or not the defense would be allowed to depose the child. It was rather extensive. Mr. Okaloosa did a very good job of laying it out all out.
Okay. I'm sorry. I'm not keyed in on this.
I said rehearing.
It's a rehearing.
Yes.
I did what I intended to do.
And we
I thought you
dispute the
said that I
state's
signed
response.
that without a hearing.
We,
But you're talking about the motion for a rehearing.
yes, and we asked it, set it for a hearing, which we did.
I got you.
And we wanted to be heard on the record as
Right.
to the basis for the rehearing. And the state's response is not correct. It's not accurate.
Okay.
That there's
Well,
no
let's-
change in circumstance. That we heavily dispute that, Judge, because we've done a lot more work. We've done
Okay.
depositions.
We need to have this on an afternoon hearing. If you want to address this, let's address it at an afternoon hearing.
Very well. And
Okay.
do we need to just? can we
I'm
set
not,
it-
I'm not withdrawing anything, let's just set this
Okay.
request for an
Thank you.
afternoon hearing.
Thank you, Your
Let's-
Honor.
Let's sit down where we can really go through it, because we just have too many cases this morning to give it its due. This is not, I don't put this in, this isn't just a procedural issue, this is a substantive.
Thank you, Your Honor. Should we just go ahead and schedule that with your
Yes.
assistant? Okay, very well. That's all we have, Your Honor.
Okay, thank you.
Your Honor, I had I don't think my colleagues opposed me pulling up a gentleman who's in a wheelchair.
Sure.
Frank Adams.
That's fine.
His brother, his twin brother is gonna
Sure.
help him approach. Frank
What is the name?
Frank Adams, Your Honor. I do not have the docket number, thank you. 36. Case number 23 CF 2078.
Give me just a second.
Adams is the last name. Your Honor.
Right, got it, okay.
Mr. Frank Adams is before the court. There's an order for competency there's an order for restoration. He's out on basically a bond that requires the implementation of the development of a restoration plan to restore his competency. The gentleman, the forensic officer with the court system who comes up with restoration plans recently retired. The court administrator is trying to come up with a plan. He represents, and his brother represents, he's doing Bridgeway and everything. He may be restorable or even restored, but we don't have an official position of the new person yet. So if we could just continue Frank Adams for maybe August 15th or something like that, hopefully we'll get a
Is August 15th a sufficient time?
I'd rather it was a month later because we don't know when that position's going to be filled.
State?
Your Honor, I think September would be better, Your Honor. I
Okay.
can report to the court that I have spoken with Kathy White from Court Administration.
Okay.
Who is
I'd be interested to hear what
filling
they're saying.
in.
I'm not aware of it either. I'm aware of what you're saying about the retirement, but
She's
not.
filling in for Mr. Barnes, in Mr. Barnes' position as much as she can, but unfortunately, a restoration plan can't be worked until that position is filled. Ms. White did let Mr. Medina and I know by email that she has reached out to Northwest Florida Health and Bridgeway to see if there's any assistance that court administration can give Mr. Barnes while we're waiting for Mr. Barnes's position to be filled. But Ms. White is aware of Mr. Adams's case, and hopefully they'll stay in contact and she can get him all the assistance that she can give.
Very good. So why don't we just continue this till September? Why don't we come back on September 17th?
Thank you, Your Honor. Got that, brother? Okay, thank you. His brother Michael's with him present. Thank you,
You
Your
can
Honor.
come forward, sir. Good.
So, 9 a.m. on
Did you get that?
September 17th. Yeah. That,
Miss Teresa, you want to do your case?
Your Honor, I have to go talk to her other person who's an inmate with a very complicated plea.
Okay, so you can't
That's
leave.
who she's waiting on.
Okay, so as soon as you do, wave at me and let's
Yes,
get
Your
you
Honor,
finished up. We appreciate your help.
Should not be very long. I just need a minute.
That's fine, that's fine, that's fine.
And then it's going to get Ms. Bosses
Sure.
out here as well. Yes, ma'am. Okay. I'll give you another.
So, next, let's, We've got just a few that have no attorneys. If you're here today without an attorney, it's, today's hearing is miscellaneous, but it's handling primarily violations of probation, so you're here probably for the first time on a violation of probation. If you do not have an attorney, you do have the right to have an attorney for a violation of probation. If you can't afford one, obviously one will be provided to you, similar to your underlying case. It's a new case, so it'll have to be newly appointed. So what we're going to do is we're going to ask you to, we're going to call your name out and have you come down, and we're going to basically take a plea for you today and appoint you an attorney, and then we'll come back at a later time after. We'll reschedule for a month from now and give you a chance to meet up with your attorney. So rather than me repeat it each time for all the people that are here, there's about a half dozen folks that are in that category. So I just thought I'd give you a general announcement. So is Daniel Lee Baker here?
Your Honor, that's 22 CF 2674 and 22 CF 2726. I don't see anyone approaching. Your Honor, so the state at this time would ask for KPS to be issued.
So ordered without bond. Ann Gaylord.
Your Honor, Ms. Gaylord is represented by Mr. Harper.
Oh,
He just notified me that today.
okay.
Just for clarification purposes, Judge, I'm not appointed to this case. However, I did represent her on some misdemeanors, in part of which were the basis for the violations of probation. So I advise the state that.
Will you probably be appointed?
Were I to be appointed today, yes.
Okay, so we'll appoint the ORCC, Mr. Harper,
Yes,
Office of Regional Conflict, and we'll enter a denial on behalf of the defendant to give you a chance to meet up with him.
Your Honor, the state is dismissing the violation of probation.
Oh, okay, like I said, state is dismissing the VOP. So you don't have to come back. You're done.
Thank you, Your Honor.
Okay, thank you. I'm sorry?
Probation reinstated, terminated?
I don't know. They're dismissing the VOP.
Yes, Your Honor, it's my understanding they should be reinstated to probation to complete the original term.
Yes, Your Honor, we're just dismissing the violation. We're not terminating probation.
So it's not affecting that, so we're not making any announcement but in the effect of this is that this violation of probation is being dismissed, but your underlying probation is back to where it was before.
Yes, sir.
Okay, do you understand?
Yes, sir.
Okay, stay in good contact with your probation officer,
Yes, sir.
okay? Thank you. Keegan Goff, if I pronounced it right. How do you pronounce that last name? Goff? Would the state announce?
Your Honor, this is case number 21CF1693.
So, Mr. Goff, as I said to you before, you do have the right with this essentially new charge to have an attorney appointed. You wish to have an attorney appointed?
Yes, sir.
Court will appoint the public defender, and as I said, I'm going to enter a denial on your behalf. That just preserves your rights, and we'll come back on August 15th at 9 a.m.
Your Honor, the state has an offer that the defendant may want to hear, if that's okay with the court. The offer is to admit the VOP, revoke and terminate probation, Okaloosa County Jail with credit for time served, waive cost of supervision, and any monetary obligations to collections.
Your Honor, sorry to interrupt.
That's right. You're welcome to
This
interrupt.
client would not be assigned to me, but I don't know where my colleagues are. If I could speak with him briefly about the offer,
Okay.
just from the Public Defender's Office?
Sure.
Your Honor, if I could have a minute to speak with him and with the state attorney.
Okay.
The original charge was a withhold of adjudication, so I just want to make sure if he takes this offer and it's adjudication of guilt that he
So
understands.
we'll pass over this and we'll
Thank
come
you.
back. Michael King.
Your Honor, this is case number 23CF947. And the state will be dismissing the violation of probation.
Okay. So it's being dismissed, so you don't have to worry. The new violation is not here. Anything that was in place before those still stands.
And
Okay.
Mr. King's termination date is listed as 6/18/24, so it should just naturally terminate.
So he should have already
Correct. The
terminated.
violation was just holding it up.
Okay. Does he need to do anything?
I don't believe so. At this point, the term is over and the state's dismissed the violation of probation.
Okay, I just want to make sure
Yes, absolutely.
he's clear. If he needs to do something, I want somebody to tell him.
He's good to go.
He's good to go? You're good to go.
Thank you.
Thank you. Daniel Knapp. I believe that's the way it's pronounced. State.
Your Honor, this is 23CF2285. I do not see anyone approaching. The state will ask for a habeas.
Court will issue a no bond habeas. Okay. Mr. Harper, I think you just have a couple. You want to do yours?
Your Honor, mine are all in custody. I don't know if you want to continue to forward.
Okay. Yeah, let's go ahead and try and finish. We don't have anybody else here.
Yes, sir. Okay,
You want to take a short break and wait, get,
I'm ready to proceed, Judge, if the court is.
go ahead. First one is Dean Fearson. Is that our first?
Yes, sir. He's number 16 on the docket.
Right?
Judge, this is Dean Pearson before the court on 23 CF 1229 and 23 CF 2568. These are violations of probation. We enter a denial at this time. He does have a new law case, 24 CF 998, which is currently set for August the 12th pretrial. I'm assuming that it should be August the 14th pretrial, but we would ask to move these cases to track along with that. Additionally, Judge, I'll be filing a motion for furlough. Mr. Pearson has advised that his brother has just passed and the funeral is this weekend. Once I can confirm with the brother the details and particulars of this, I'll provide that both to the state or to the court in a motion for the court's consideration, Judge.
Okay. Madam Clerk, can you run all these together at August 14th and his other case also for August 14th?
Yes, sir.
It'll be at 9 o'clock. Thank you.
I don't know if the state can give me a guide. He just wants to know what the guidelines are for this.
Sure. Let me just pull that up for you. So the guidelines are 20.93 months.
Gotcha. I'll work on it. Okay. Swear, Mr. Pearson. All right, next, Judge, should be Austin.
Council approach?
Yes, Judge.
Please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared.
Judge, Mr. Fink at this time is going to admit the violation of probation and be adjudicated guilty, sentenced to 9 months in the Okaloosa County Jail, credit for all time served, assess all applicable court costs, costs to be sent to judgments, I apologize, and revoke and terminate supervision.
That is the state's agreement, Your Honor. Mr. Fink was on supervision for misdemeanor.
I'm just writing that last part down, Judge. I realized we didn't discuss it. Revoke and terminate supervision.
Yeah, I was going to mention that too. Okay.
Your Honor, if I may approach, this is a misdemeanor, so there's no score sheet.
Thank you. Mr. Fink, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard the terms of the plea agreement. I see those same terms are written down here in your written plea agreement that you've signed. Just want to make sure, have you gone over this in detail with your attorney, you've read through it closely?
Yes, sir.
You understand you're waiving the right to go to a trial.
Yes, sir.
That's an important constitutional right that you have. We just want to make sure you're clear about it and you're entering into this freely and voluntarily.
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt. There's an admission of the VOP, I assume. It doesn't actually, I don't know that it says that.
Yes, sir.
I assume there's
He does admit the violation.
Yeah. And the court is sentencing you to 9 months in the county jail. You will get credit for all time served, and all applicable court costs and fees will be sent to judgment. And when you get out, court is revoking and, well, not, it's doing it now, but revoking and terminating supervision so that when you get out, you're done.
Yes, sir.
Okay? Any questions?
Yes, sir.
Okay, thank you.
Thank you.
And the last one I have, Judge, is number 31 on the docket, Jonathan Holcomb. I was appointed to this case last week.
Okay.
Judge, he's before the court on 23 CF 355 and 24 CF 958. Judge, these are technical violations. He entered a denial at this time, and we're asking to set this on the next miscellaneous without subpoenas. Mr. Holcomb is asking to get screened for certain treatment programs, and we'll see if we can't incorporate that into a resolution.
So for today, we just want to deny and we'll come back in a month?
Yes, sir.
Okay. Come back on August 15th at 9 a.m.
And Your Honor, may I correct real briefly?
Sure. Sure. And then after that, we are going to take a short break after Mr. Goff. Mr. Goff, you can come back up. We have a written agreement.
Yes, Your Honor, we do.
You want to go ahead and announce it for me?
Yes, Your Honor, this is Keegan Goff, 2021 CF 1693. Mr. Goff will admit the VOP. I only have the one copy.
That's all right. That's all right.
He'll admit the VOP, revoke and terminate supervision, Okaloosa County Jail with credit for all time served, $100 cost of prosecution with 180 days to pay, waive cost of supervisions, and then any monetary obligations that are outstanding will go to a civil lien. I'm not sure if you'd like me to sign this agreement because our office wasn't really assigned, so if I can approach.
If she's not formally appointed, it saves you $100.
And Your Honor, that is the state's agreement.
Okay. So, Mr. Goff, would you raise your right hand and let me ask you a few questions? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, I heard the terms of the plea agreement, and I see those same terms are contained in the written plea agreement that you've signed. Have you read through this and gone over it in your satisfaction to where you understand what this plea agreement is?
Yes, sir.
You understand that by entering into this agreement, you're waiving the right to go to a final hearing, force the state to prove their case. You're waiving it so it'll be a final adjudication of this matter. Do you understand that?
Yes, sir.
Okay. And you're entering this freely and voluntarily?
Correct, yes, sir.
And do you have any further questions regarding this agreement?
No, she answered everything.
Okay.
Yes, sir.
Very good. Based upon that, the court will accept the plea agreement. There'll be an admission of the VOP by the defendant. Court will revoke and terminate probation. You are sentenced, the technical sentence is credit for time served. Which does not mean you won't have to serve any additional time. There is a $100 cost of prosecution and all monetary, well, it says all monetary obligation is civil lien. I'm gonna scratch through that because the 180 days to pay is what kind of what applies in this case. So you've got 180 days to pay the cost of prosecution. The reason why I give you the 180 days, if you don't pay it then they go after your driver's license.
Okay.
So make sure and try and get that paid, pay it in a few installments and get it knocked out.
Yes, sir.
Okay? Any questions?
No, sir.
Okay, thank you very much. Ms. Teresa, are you ready?
Yes, I am.
And then we're going to take a break.
Oh, yeah, you're talking about the interpreter, Your Honor?
Yeah. Are you ready?
Yes, we're ready, Your Honor. Your Honor.
I got to get a throat lozenge.
Your Honors, we're calling Garstein, Eli, Erazo, Vasquez, and I will provide the court the docket number momentarily. Thank you.
And Your Honor, it appears there were only 2 of his cases listed on the original docket, but we're actually addressing all 4 of the cases.
Yes, Your Honor, and I'll be stating those names, case numbers, and he will be signing an agreement listing all the 4 case numbers.
Tell me the name again so I can find it.
Yes, Your Honor. Last name, it's a double last name, Hispanic format, Erazo, E-R-A-Z-O. And his second last name is Vasquez, V-A-S-Q-U-E-Z.
Got it. Thank you.
Your Honor, we have been over the agreement 3 or 4 times, including a final discussion this morning. And Mr. Erazo Vasquez is signing his agreement that's been negotiated with the state.
Thank you.
And I'm providing that to the state for Ms. Basso to sign, Your Honor. And your signature is on, carried over to the 5th page, Mayor. And Your Honor, I've been over the revised score sheet with Mr. Arazo Vasquez, and he understands what the score sheet says, and it is going to be a legitimate, uncoerced plea bargain, downward departure.
Very good.
Mr. Medina?
Thank you. I'll give it back to you. Your Honor, I'm approaching with the agreement and the score sheet, and I'm going to provide probation a copy because it is a complicated deal. And he has a copy probably back at the jail, but I'm going to, I gave him a second copy of the front page. I'm going to just copy it on my phone. You can hold on to that. Your Honor, Gerson Eli Arazo Vasquez is before the court with a plea and sentence agreement that's been signed by all parties, resolving 4 cases: 23 CF 280, 23 CF 503, 24 CF 253, and 24 CF 254. Under the terms of the plea and sentence agreement, he will be pleading no contest to lesser included offenses as follows. Adjudication of guilt on each charge in each case, to lesser included offense, lewd or lascivious conduct. That is a second-degree felony, level 6. He understands that each of those second-degree felonies subjects him to a maximum incarceration of 15 years for a total maximum incarceration that will be in place where he violate his probation of 60 years prison. There will be a 15-year concurrent sexual offender probation term that's concurrent between all cases and counts. There will be a requirement for GPS at $1 a day. There will be no contact with the victims. The victims' initials and dates of birth are indicated in a parenthetical. I will not read them individually unless the court wishes me to do so.
No, thank you. No, not necessary.
It would be not only no contact with those victims, but also no contact with their families. There will be also no contact with minors. So you understand a minor would be anybody under the 18 years of age. And there will also be a sexual offender designation and all requirements of Section 943.0435 Florida statutes. And there will be 867 court costs times 4 because there are 4 cases. A total of $450 public defender fees, including the $50 application to the clerk. And before I stop talking, Your Honor, there are 2 important background points I wish to make. First is that he is not a legal U.S. resident or citizen, and I have given him no immigration advice. However, the state of Florida is doing this legitimate uncoerced plea bargain, and I'm sure Ms. Bossa will say some things about this, at the request of the minor victims' families. Their mothers were deposed, and this is what they all wanted. They had in fact written letters approximately a year ago that we learned of through the depositions. And this is what the families want on the conditions that are spelled out in this agreement of absolutely no contact with the victims or their families. And further, they are the victims, and the state of Florida is doing this agreement because they anticipate that he will be deported. He is from Honduras, and that is the expectation of the state. I have not given him any advice. I've explained the deal, how it would work if he gets deported the best I can, as well as how it would work if he doesn't get deported. And he understands the agreement, and I think those were the preliminary matters I needed to reference, Your Honor.
Your Honor, Mr. Medina has stated accurately. Your Honor, Mr. Medina has stated accurately that the victims were actually consulted as to this plea agreement. They are on board with it. Their biggest concern was the no contact. Also, there have been no representations made by the state as to whether or not he would be deported or what his status would be. That would be entirely up to immigration, of course. But the key thing is for us, Your Honor, the victims are on board, so the state is in agreement with this agreement.
So, Mr. Vasquez, I need to ask you a few questions. Would you raise your right hand, please? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of your plea agreement. And those terms are also contained. I don't see a signature on this by the defendant.
May I, Your Honor, I thought he signed it.
Oh, there it is. No, I've got it. I've got it.
I think I signed it too, Your Honor.
You did. There was just another space in it.
Yes,
That's fine. That's fine. So, Mr. Vasquez, you've heard your attorney state the terms of the plea agreement. It's been translated for you as it was explained, and it's in writing in this written plea agreement that you've signed. Have you been able to read this closely? I know that this is not your first language, but do you understand the terms of this plea agreement?
I understand them.
And you've had all your legal questions answered by your attorney?
That is correct.
I assume, and I'm asking you whether you have had extensive conversations with your attorney about the terms of this plea agreement?
Yes, we had, Your Honor.
And do you feel like you have any other legal questions regarding this plea agreement?
No, Your Honor.
You understand that by entering into this plea agreement here today, this will be a final resolution in your case. You will obviously be on probation, but the underlying resolution of your case will be done. You're not going to have to go to a trial on these charges. Do you understand that?
I understand, Your Honor.
And do you believe it's in your best interest to waive the right to go to a trial and to enter this plea agreement as it's outlined in it, in the agreement?
I understand, yes.
And I assume there's a factual basis, no DNA evidence.
That is correct, Your Honor.
Yes, Your Honor.
Very good. Based upon that testimony, then, Mr. Vasquez, the court will accept this plea agreement. There will be an adjudication of guilt as to each charge, And these are the lesser included charges. The statutory cite is contained in the agreement, Madam Clerk. These are all identical lesser included charges of lewd or lascivious conduct. And for each of the 4 cases, the defendant is sentenced to 15 years, sex offender probation. For each of the 4 cases, they will all be served concurrently. You will be required as a condition of the probation to have a GPS monitor at $1 a day. And very importantly, there must be no contact with the victims. And the date of birth and the initials of the victims are contained in the plea agreement to make sure that those are clear. I think everybody is clear about the victims. There also can be no contact with their families. What does that mean?
That would include.
What does no contact with the families mean? What I'm asking is, I'm a little bit concerned that the term families is not sufficiently defined. A family can be a second cousin. Could be the immediate family only. If he's being bound by it, I would rather it be clear in here so that he can be bound by it.
Yes, Your Honor. The state's intent is that it be the victims themselves, any siblings of those victims, and then the parents of those victims. So basically, we're talking immediate family.
Immediate. So this agreement, and Mr. Medina, do you agree with that, that definition?
Very appropriately stated, Your Honor.
Okay, and that's clear. I just wanted to make sure that that is clear, that it's not more extended family.
No, Your Honor, that was not the intention.
So
May I?
you may.
I just want to make sure that he understands, because of this immediate family definition, that does not mean that you can indirectly contact other people and then contact the family.
I'm actually going to go over that with him a little
Okay,
bit.
thank you.
No, I appreciate it.
Thank you.
So, in addition, the additional requirement that there be no contact with any minors. That's anybody under the age of 18. And there will be a sex offender designation in all the requirements of Florida Statute 943.0435. And you have the statutory court cost and public defender fees. So that's the terms of your agreement, that's the sentence. But I would make sure to understand, make sure you understand the importance of the no contact. The no contact is central to this plea agreement. And in this case, this no contact is one-sided. What I mean by that is you can have no contact with them. If they reach out, I'm not saying they will, but if they would reach out, somebody in the family would reach out to talk to you, and you allow that to happen, you would be in violation. They would not. So it is incumbent on you to stay away from them and to have no contact. And as your attorney was explaining to you before I interrupted him, it is important that you understand that means no direct contact. In other words, you can't pick up the phone or text them or walk up to them in public, that type of contact. It also means third-party contact. So you can't have a friend of yours contact them. That would be third-party contact. You're not contacting, you're contacting somebody else who contacts them. That also is contact, and that is not allowed. This is no contact. Is there any question that you have about that?
No, señor.
Your Honor,
No, Your Honor.
You may?
may I also just explain to him that would, another way of putting it, if I may, Your Honor, is no direct or indirect contact with the victims or their families.
Do you have any questions concerning any of this? And, by the way, your attorney mentioned this, but I'm going to say to you that when we enter these plea agreements, we do not take into account any immigration laws. Those are federal laws that are dealt with another agency in another court of law. And so we don't know the effect of this. I will say that sometimes what we do in state courts can affect your immigration status. Do you understand that?
Lo entiendo.
I understand.
But we don't know what that is, and we're making no assertion that there would be any impact on immigration. That's separate.
May I add to that?
You may?
What you're pleading out to subjects you to deportation, but we
Yes.
do not know that you will be deported, but you're subject to deportation.
That would be a better way technically to say it. Any question?
No, señor.
May I add one
No,
more
sir.
thing? Actually, two more. My Spanish is not very good, but when Your Honor asked him if he felt this was in his best interest, he said, "I understand," but I think he also needs to say that, yes, he does believe that it is in his best interest, to make it clear on that answer.
Do you believe this agreement is in your best interest?
Lo es, señoría.
It is, Your Honor.
And, Judge, I'm sorry, I had one other random thought, and I am going to do my best to send him a copy of his score sheet as soon as I can, and I think that's all I have to say.
Probation?
The CPS to be placed upon him before it's released.
That is correct. Thank you. Thank you for that request for clarification.
Your Honor, there is no control, I don't think, by the jail of immigration. So if immigration were to come and get him before he has the GPS put in place, that could happen. But he knows if he's in the United States, if he has a tow in the United States, he's required to get a GPS monitor and comply with everything, even if it's not put in place before he leaves the jail.
Any further questions, sir?
Sí, ¿qué tiempo tengo que hacer? ¿Puedo salir hoy mismo?
So how long, when am I going to be eligible to be released? Is it going to be today?
I mean, generally, I can't, I'm not responsible for that, but if this is the only issue, probably be processed out today, I would guess. Probation, do you have any?
Maybe tomorrow morning, because our prosecutor office puts up the GPS, so as soon as we
Okay.
get the finish sheets, and they sign out.
And if you do get released today or tomorrow, you need to not only report first thing in the morning, tomorrow morning, but you also, the address, at probation is going to give you a piece of paper with the address. Thank you, Your Honor.
Thank you.
That is what I have, Your Honor.
Thank you.
Thank you, sir.
Thank you, ma'am.
You're welcome.
Do you want to do all out of custodies, and then we'll take a short break?
Yes, sir, I think we can.
Mr. Gates, do you have any of your?
I do have 2 out of custody, Your Honor.
Okay.
I don't know the number they're going to get a doctor, but I've got them.
That's all right. Just yell them out, and I'll get them.
Austin Hayes, I had as number 29 on the docket, Your Honor.
Very good.
Your Honor, this is Mr. Hayes before the court in 24 CF 96. I was reading the PUP affidavit. The allegations were possession of drugs, specifically possession of some paraphernalia that was part of an office report. Mr. Hayes was not actually charged with anything. In fact, there was a traffic citation issued for intent violation. So I'm kind of perplexed as to why they would violate him for possession of paraphernalia when there was no arrest report at all cited. In fact, it's a traffic ticket. Traffic citations typically aren't basis for violation. With that said, there was the allegation of complete treatment, but he's been working on getting that treatment completed. So if we can enter a denial today, continue without subpoenas.
We'll denial and continue to 8:15 at 9 a.m.
Yes, Your Honor.
Okay.
The next I've got, Your Honor, is going to be Mr. Sean Paul Kamsoon, number 34 on the docket, Your Honor.
Okay.
We left him for today as a status, Your Honor. We have a PTI plea agreement to be filed in his case. A copy of what I need. The state will have to file a score sheet later on this one, Your Honor.
Thank you.
Give probation copies as well, Your Honor.
Here, that's just the first page. You want to announce the terms?
Yes, sir. Mr. Kamsoon will be entering the plea contest as charged. In exchange for entering that plea, the state has agreed to place him into the pre-trial medication program with the terms outlined in the PTI referral, which everybody signed as well, Your Honor. If upon completion of the PTI program, Mr. Kamsoon's plea would be withdrawn, the charges would be dismissed. If he fails to complete the program, then he will come back for sentencing on the case before the court.
State.
That is the state's agreement, Your Honor.
Mr. Kamsoon, would you raise your right hand?
Yes, sir.
Swear or affirm the information you're about to provide this court is the truth?
Yes, sir.
Nothing but the truth, so help you God.
Yes, sir.
So you heard your attorney explain the terms of this agreement?
Yes, sir.
It's in writing, you signed?
Yes, sir.
Do you understand the terms?
Yeah, the
You
most
complete the
important thing
PTI or you come back?
Yes, sir.
Do you understand that?
Yes, sir.
Any questions?
No, sir.
You had all your legal questions answered? Do you have any legal questions that you have for him?
Did I answer all your questions?
Yeah, he already
All
answered.
questions?
Yes, sir.
Okay, very good. So the court will accept the plea agreement. Okay. Thank you.
That's all the evidence that they have at this time, Your Honor.
Okay.
Your Honor, court security informed me that Daniel Baker has arrived in the courtroom.
Okay.
We had called this case and it issued a
Mr. Baker, you can come forward.
Yes, sir.
Would you announce the cases?
Yes, Your Honor, that is 22 CF 2674 and 22 CF 2726. Your Honor, Mr. Baker was here this morning for a violation of probation.
Mr. Baker, you need to figure out how to get places on time. That's first order of business.
Yes, sir.
So the court will withdraw the capias at this point. With this violation of probation is essentially a new charge. So you do have a right to have an attorney appointed with those new charges. If you cannot afford an attorney, one will be appointed. So you want the court to appoint the public defender?
I just want to try to get this over with. Y'all
Okay, you guys got a plea? You got an agreement,
Your
an
Honor,
offer?
the state's offer is to convert the remainder of his probation to community control. I didn't see where he's been on community control before, so I'm not sure he knows what that entails. So I don't know if that's something that he'd be willing to accept today.
I'm just asking this, sir. I done went to Keaton. I done graduated Keaton. I saved 2 lives while I was in Keaton. I done came over here. I hadn't filled no drug test since being put on probation. You know, I'm just trying to get off this stuff, sir. I just want to just go on, and you know what I'm saying? They wouldn't offer me regular probation when I first asked. They said no. They want me to go to Keaton. They want me to do this. They want me to do that. I'm just asking just one time, sir.
Mr. Baker, this is a procedural hearing. I'm not here to, I've got 100 cases today.
I understand.
I can't go through in the substance of all. I'm not disputing it. I'm just saying we don't have the time to go over it. I think you ought to, let's just appoint you an attorney. I'm going to enter a denial, and we'll come back on August 15th, and hopefully you can get some resolution on it, okay?
Okay.
Okay, so the court will appoint the public
Your Honor,
defender.
is this a request for early termination?
No, it's a
No.
violation.
Oh, it is a violation.
This is a
What is his last name?
Baker.
Your Honor, I'm going to give him a card with my assistant's name written on there. I would ask that he complete the public defender's application for
Sure.
maybe a reappointment official. And fully complete it and turn it in on the first floor before he leaves the court today.
Okay.
Understand? Clerk's office on the first floor?
Yes.
Is there anything?
Thank you. Mr. Medina or Ms. Farkas, do you have any out of custody?
I don't believe I have any.
Ms. Medina, you got a couple folks here?
I'm not aware that I have any, Your Honor. I don't think I have
Okay.
any until the afternoon that are out of custody. I have a lot of in custody.
Sure. We'll take a break and then we'll do all the in custodies here this morning.
Your Honor, I was wrong. I have one out of custody client.
Great, let's do it.
This is William Davis Jr. There are 2 VOPs, 2023 CF 155, 2024 CF 614. If we could enter a denial, this is the first time. I'm sorry, I think the other one is not a VOP, it's a new case. I apologize.
It's all right.
Enter a denial on the VOP and continue both cases, please.
And the new case is, let's try and track them together. What is the new case?
Yes, the
Jan?
new case is 2024 CF 614.
Let's see what that one. It's what? That one's on the docket today?
Yes.
Okay.
I just mislabeled it as a VOP.
So it's labeled as a VOP. Is this a VOP or not? You said there were 3 cases. I've got 2 cases.
It's
They're
just 2
both
cases.
listed VOPs.
24 CF 614 is a VOP as well.
Oh.
Okay. So you're going to deny both and we'll come
Yes.
back on 8/15.
Yes, Your Honor. Thank you.
Okay? Just meet up with your attorney in the interim. Is anybody here that thinks they've got a hearing this morning? Okay, good. So let's take a short break and we'll come back and finish up the rest of the docket this morning.
Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Can I send an agreement back for a couple people?
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I've got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm Attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100.
And do your females first.
Your Honor, first, I believe, will be Leeta Carter.
Very good.
2023 CF 1265 and 2024 CF 1044. The state and the defense have reached an agreement in this case. It will also include a misdemeanor that she has in these cases. I'm sorry. I've discussed it with Ms. Carter at length, and I'll just have her sign it when she gets it.
What's the misdemeanor case number?
The misdemeanor case number is 24MM1686. It's a petty theft.
Okay.
Your Honor, this is Leeta Carter, 2023 CF 1265, 2024 CF 1044, and then the misdemeanor that she has will also be included, 2024 MM1686. The state and the defense have reached an agreement. If I can approach with the agreement after Ms. Carter signs it. Your Honor, if I may approach.
Thank you. Did you announce?
Yes, Your Honor. In 2023 CF 1265, count 1 is a felony VOP. It was a previous adjudication of guilt. Ms. Carter will admit the VOP. She'll be sentenced to 12, 1 year DOC, 12-1 DOC, concurrent to count 1 in 24 CF 1044, credit for all time served, $150 public defender fee, $100 cost of prosecution, revoke and terminate supervision, 180 days to pay after release. Counts 2 and 3 are previous adjudication of guilt. They're misdemeanor VOPs. She'll admit the VOPs on both, credit for all time served. 2024 MM 1686 is the misdemeanor petty theft. Adjudicate guilty, credit for all time served. No trespassing of the Salvation Army, 425 Mary Esther cutoff. $270 in court costs, $150 public defender fee, and 180 days to pay after release. 2024, CF 1044, singular count of possession of a controlled substance. Adjudicate guilty, 12-1 DOC, concurrent to the other DOC time. Credit for all time served, $150 public defender fee, $615 in court costs, and 180 days to pay after release.
Your Honor, that's the state's agreement.
Ms. Carter, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, Ms. Carter, you heard your attorney state the terms of the plea agreement, and I'm going to simplify it a little bit. You've got 2 felony violations of probation or felony charges, and you've got 3 misdemeanors. The misdemeanors are credit for time served, they're finished. The 2 felony charges are, you will get credit for all time served, but you're sentenced to 12.1 months in the Department of Corrections. And those are running concurrent, they run at the same time, so that's a total of 12.1 minus the credit for time served. Is that your understanding of what the agreement is? And you believe that's in your best interest to resolve this through this plea agreement here today?
I guess that's what they say.
No, it's not what they say. Now is when I get to talk to you. You got to tell me what you say. You believe that? Well, I understand that, but you're having to deal with these charges.
And yes, I know. Yes,
I don't think you're going to go home with this plea agreement. Oh, I don't know. What's the approximate credit for time served?
Your Honor, I believe she has about 4 months worth of credit, though I've let her know that the jail does that calculation. I think she's got about 4 months.
when you get a new charge, they don't have, it's only right now.
Okay, so, but we're not making the calculation, but you're not going to be able to go home.
I've informed Ms. Carter that this is a downward departure in her score sheet. The 12.1 DOC is a downward departure. I let her know that she scores. I did. We just spoke about it back there, Your Honor, that she scores just over 17 months DOC.
Okay, so the main thing I want.
That's what I just wanted to reiterate what Ms. Farkas is saying, Your Honor, that this is the state offering a downward departure of a good chunk of months.
So the main thing I want to hear from you, this is, you don't have to tell me this, but that's what I'm asking you. I want to make sure you understand what you're doing here today and that you're doing so freely and voluntarily. Nobody's twisting your arm to do this today. You understand that? You don't have to enter this agreement today. Do you understand that?
Yes, sir.
Okay.
So I don't have to do it right now?
You do not have to do it. No, ma'am.
Can I wait?
Sure. If you'd like to continue the cases, we can do that.
Okay. So we'll just continue this matter till next month.
Thank you, Your Honor. On
So we'll
8/15.
continue it until 8/15.
Thank you, sir.
Okay, thank you.
Your Honor, this is one second. All right, there are two VOPs before you, 2021 CF 2665 and 2023 CF 905. Per probation's recommendation, Ms. Carthon was evaluated for drug court. We received an email from Terry Henderson with drug court that she's been approved. She's a great candidate. I believe she observed yesterday. Yesterday, yes. And she's going to plead into drug court on 7/17. So I believe that we'll take these cases off the docket. Ms. Henderson asked that we continue it for a couple weeks.
Sure. Well, why don't we continue until the next court date, which is August 15th.
Okay.
But we'll assume that it'll be off the docket by then.
Yes.
You'll be in drug court.
I believe that this is her arraignment on the VOPs, so just, I'll put on the record that she is entering a denial to them.
Very good. Good job. Thank you.
Thank you, Your Honor.
Good luck, ma'am.
Your Honor, this is Miranda Fair, 2022 CF 3146. This is a VOP, and the state and the defense have reached an agreement in this case. Let me just make sure that everyone's signed it. I didn't sign it. If I may approach, Your Honor.
You may.
Your Honor, there are two counts here. They are both a previous withhold of adjudication. In count one, Ms. Fair will admit the VOP. It will remain a withhold of adjudication as she's being reinstated on probation and modified to 1 year of community control and the remainder on standard felony probation. The supervision termination date will remain the same, so it's not an additional year, it's just converting it. $150 public defender fee, $100 cost of prosecution. The second count is a misdemeanor VOP. Ms. Fair will admit that VOP, withhold of adjudication, revoke and terminate any supervision that she was on.
That is the state's agreement, Your Honor.
Ms. Fair, would you raise your right hand? Do you swear or affirm the information you're about to provide this court?
Yes,
The
sir.
truth and nothing but the truth, so help you God.
Yes, sir.
So you heard your attorney state the terms of the plea agreement. The misdemeanor violation, misdemeanor VOP is going to revoke and terminate, so that'll be finished. Okay? The other one, we're going to modify. You're going to have a year of community control. It's a little higher supervision. You know, they're going to be poking around even more than what you've been dealing with. You prepared to do that?
Yes, sir.
I mean, everybody wants to get out, you know, sign, let me sign. But, you know, tomorrow you got to stay on this thing.
I have the support system I need, so I believe I'm ready for this.
That's very important. The main thing, not the main thing, in addition to the support system though, one of the important things is stay in good contact with your probation officer, okay? So you've reviewed this, you believe this is in your best interest to enter into this plea?
Yes, sir.
And you understand that you're waiving the right to go to a trial, a hearing on this VOP and all this?
Yes, sir.
Okay. Based upon that, the court will accept your plea. There'll be an admission of VOPs in both of them. Count two, it'll revoke and terminate supervision, continue with the withhold. Count one, also continue with the withhold, reinstate and modify supervision for 1 year of community control and the remainder on standard felonies. You are not extending your probation. You're just adding the community control, which is essentially house arrest.
Yes, sir.
Okay. Any questions?
No, sir.
Good luck, man.
Thank you.
All right, Your Honor, next up is Tiffany Armstrong. I believe she's on the docket as Tiffany Tenor. It's a bond hearing. The three dockets that are on for the bond hearing are the VOPs that are holding her in. 2023 CF 1556, 2023 CF 2163, and 2023 CF 1986. The new law is, just for the court's record, 2024 CF 820.
Which is, what are the charges?
There are 4 charges there: sale, manufacture, deliver, possess, possession of controlled substance, possession of paraphernalia, and a 4th charge that is escaping me.
That's fine.
Resisting without violence, I believe. That's okay. I think it's resisting without violence, Your Honor.
Okay.
So as for the bond, Ms. Armstrong was granted a bond in the new case. It's only the VOPs that are holding her in. She has had no other violations of probation. I spoke with probation this morning. She was on probation for almost 6 months without issue.
No other charge other than a new law charge of
Yes, Your Honor. In the new case.
distribution.
Yes, if I can address the new case, just as it relates to the VOPs. I have spoken with the state attorney about this case a few times. I believe that I have exculpatory evidence that I've started discussing with the state. And further, we did put in a discovery demand on May 30th, and we don't yet have any discovery. There's no FDLE, there's nothing so far. And that in conjunction with the fact that the state and I are discussing it. As for Ms. Armstrong's community support, like I said, she was on probation for almost 6 months with no issue. She was paying monthly. She just signed up for the community service and the anti-theft course. She was waiting for the referral for the anger management classes. Those referrals can take a couple months, but she was signed up for the wait list. She has a stable address with her mother and children in Fort Walton Beach. Her mother and daughter provided letters. I'm not sure if they were sent to the court or just sent to our office, but I think it is relevant to her bond that her mother was diagnosed with Alzheimer's disease last year, and Ms. Armstrong is the person who takes her to all of the meetings, the doctor's appointments. She's in a trial for Alzheimer's, and it's Ms. Armstrong's it is her job to take her mom to all these appointments. I'm happy to read her mom's letter into the record, but I think I can speak to what she says there. In addition, Ms. Armstrong has 2 children, the youngest of which is a 5-year-old daughter who's diagnosed with autism. Ms. Armstrong's mother also provided the diagnosis sheet. And her mother really reiterates that Ms. Armstrong is the only person who can really calm her daughter down when she's having issues with the autism diagnosis. I also have a letter from Dana Claw of ECLC at the jail. Ms. Armstrong has been consistently attending ECLC at the jail. Ms. Claw notes her growth and progress there, regular attendance. Ms. Armstrong, I'm sorry?
You want to give me the acronym?
Oh, I'm sorry, I get on a roll. The Emerald Coast Life Center. It's a faith-based, I guess, kind of rehabilitation program at the jail that's been really successful with a lot of people. The bottom line, Your Honor, is that Ms. Armstrong understands she has new charges and they are serious charges, but she was absolutely able to comply with the terms of probation prior to this. She was working full-time at Sonny's Barbecue. She has very strong community support and also family who needs her. And given that she was granted a bond in the new case, I think it indicates that she could be granted a bond in this one, and the court, she would absolutely return herself to court. She has every reason to. She's open to an ankle monitor or any sort of...
With all due respect, counsel.
Yes, Your Honor.
The fact that she has a bond in the new case is always what happens, and they no bond the VOB.
I
That is
understand.
standard procedure. And
That's
the fact
true, Your
that
Honor.
she was offered the first bond has no relevance to the no bonding of the other ones.
I think my point in raising that, Your Honor, is just that the bond in the new case is something that she would absolutely be able to pay. And the judge in that case could have set a much higher bond, I suppose, for whatever reason.
What is the new law case?
2024 CF 820.
I'm sorry, last three?
820? Yes, Your Honor.
Okay, hold on.
Your Honor, I think she was granted a $2,000 cash or professional bond on counts, yeah, 1 and 2. Let me, when I was looking at what bond she had on.
Yeah, I've got 2 on each.
State?
Your Honor, given that there is a new law violation which she has been arrested for while she's on bond, the state would object to her receiving a bond on the violation of probation. However, there is some there potentially. I don't know what's going to be in it, but there is some evidence that has been brought to my attention that may exist. So at this time, the state objects, Your Honor.
What's the exculpatory evidence?
Your Honor,
What's the nature of it?
they were someone else's drugs and she was asked to hold them so that the other person in the car would not get arrested. It's apparently messages to that effect, Your Honor. I'm attempting to see if that evidence exists. I don't know if that would change the court's. I just bring that up to say if the court is inclined to know if that evidence exists prior to us finishing this bond hearing, if we want to see her again next week. At this time, the state doesn't even know if that evidence exists. So I'm looking for, the state's looking for it. So right now, I would have to object to the bond, but I don't know if that would change the court's ruling on whether she should receive a bond or not, Your Honor. So I just want to bring that up for the court and let the court know that if you want to wait until next week to make a ruling on the bond or not, I think that's at the court's discretion.
I mean, if you want to come back and you know, the state might have a different position, but.
Well, certainly if
I
they.
mean, picking up a new law charge of the type that has been alleged, including distribution level amounts, is not something, that's the reason why you no bond right there. That's it. That is exactly the reason. You've got three cases you're out on and you pick up a distribution level charge. If the state comes back and says, oh, it's not what it looks like, they can come back and look at it. So if you want to continue it for a month, that's fine. Let the state review that. But based on what I've seen so far, look, I'm sympathetic, and just for the world to see, well, I'd say, if you want to help your relatives, try not getting arrested. That would be the best way that you can help your parents if you're in home care.
Yes, Your Honor.
Not subjecting the public to distribution of drugs while you're out on probation on 3 separate counts.
Your Honor, to that effect, I just want to reiterate that in the new case, we don't yet have discovery, which I have spoken
Sure,
with
I
Ms.
understand
Sharpless
that,
about.
and I'm sensitive to that. You need to,
Your Honor.
where are
so
we at on that?
I did just send some stuff to the public defender's office. There was a miscommunication. The intake had been done by me, but there was no attorney on it when I did that. So when she entered a notice, it looks like it did not get sent to her. So I just did that while we were sitting here.
Okay. Was there an FDLE report?
No, Your Honor, there's not yet an FDLE report.
Okay. So you want to continue this till 8:15 or just?
I suppose we can continue it to 8:15
Or
and that
just
will.
wait and put it back on if you come up with some new information?
Thank you, Your Honor.
Judge Ketchel? Your Honor, I have detention hearings with Judge Montero. May I please?
Sure.
Ms. Sharpless said she'll cover the rest.
She'll cover for you?
She'll cover what I have left.
Okay, well, you got your wingmen, wing women. The wingman is gone.
He is, unfortunately.
Your Honor, this is Reginald Castor. I'm just going to have him sign the plea agreement that we discussed at the jail yesterday. Your Honor, if I may approach.
You may.
Your Honor, there are two dockets before you, 2022 CF 810 and 2022 CF 2815. The state and the defense have reached an agreement here in 22 CF 810. This was a previous adjudication of guilt. Mr. Castor will admit the VOP, receive credit for all time served, revoke and terminate supervision, $150 public defender fee, and $100 cost of prosecution. In 22-281, CF 2815, a singular count, previous adjudication of guilt, admit the VOP, reinstate and modify, convert to community control for the remainder of the term of supervision, and that would be that.
State?
That's the state's agreement, Your Honor.
Mr. Castro, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. I see those terms are contained in the written agreement, which you've signed. Have you gone over with your attorney? Make sure you understand all the legal ins and outs?
Yes, sir.
You understand that by entering this, you can put your hand out. By entering into this, you're waiving the right to go to a trial. The state has to prove their case. This will be a final resolution.
Yes, sir.
And you're entering this freely and voluntarily?
Yes, sir.
And you've had all your legal questions answered?
Yes, sir.
Okay, based upon that, the court will accept your plea agreement as to 22 CF 810. That's the misdemeanor VOP. Court will, there'll be a previous adjudication of guilt. You will get credit for time served, and the court will revoke and terminate supervision, so that won't be done, plus some fees and costs. 22 CF 2815. Again, previous adjudication of guilt. In this case, you'll reinstate and modify. This will be converted to a community control for the remainder of the term. It's important because that community control is house arrest. And you know the game. The game is I give you I made a pretrial intervention, I made a probation, community control. Next step. What I'm saying to you is if you violate on the community control, they're going to be asking for prison or jail. You understand that?
Yes, sir.
Don't want you to do that. We got the jail full. We got enough people over there. We need you to stay out, stay on community control. Can you do that?
Yes, sir.
Okay, the key is you got to stay in close contact with that probation officer.
Yes.
Okay?
And just for probation, Mr. Castor was previously living in Gainesville and would like to go back there. So I know that's, y'all will talk about that, but just wanted to get that on the record. That he's
Okay.
hoping- He was living and working over there, so.
Okay, same thing, stay in touch with them over there, wherever you're at.
Yes, sir.
Okay, that's up to you, that's the key thing, you gotta stay in contact, okay?
Yes,
If
sir.
I could add the time to pay on the first case, I just want to make sure that
Sure,
that doesn't get.
sure.
Thank you.
Any questions?
No, sir.
Okay.
Thank you, I appreciate it.
Thank you.
I need to ask you something else.
Oh, what's up? Thank you, Your Honor. Your Honor, this is Jimmy Clanton, 2023 CF2522. He also has a new law case that is on for arraignment this afternoon, 2024 CF1348. In both cases, he'll enter a denial and a plea of not guilty. I've been speaking with Mr. Clanton and with the state about these cases and hoping that we'll be able to resolve them pretty quickly.
Okay, hold on just a second. So on the new law charge, you're entering a not guilty plea?
Yes, Your Honor.
Are we going to run these together?
Yes, please.
So, you want to put them on the pretrial?
August 14th.
That would be great.
Okay. August 14th on the VOP as well.
Okay, thank you. Thank you. Your Honor, this is Leroy Figures. He has 2 VOPs and a new law that is on for arraignment this afternoon. The VOPs are 2023 CF1390 and 2023 CF1120. Would you like the new docket?
24 CF 1008.
Yes, that's the one, Your Honor. Mr. Figures would like to enter a plea of not guilty in the new case. Just for the record, and I'm not sure if this is the same situation as the other, I filed a demand for discovery on May 14th in this case and still do not have any discovery, so it's been almost 2 months. And
Where are
this
we at?
case,
Your Honor, the state filed a discovery exhibit, I believe it was either yesterday or the day before, and the discovery documents are on their way to the public defender's office.
Is there a reason why it's taking that long to get these discovery requests? This is the second one.
Your Honor, may we approach?
Sure. Ms. Sharpless, you want to come on up and join the party?
Civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the
So on the BOPs, we're entering a denial, and we'll run them all together till 8 to 8:14 at 9 a.m.
Thank you, Your Honor. Thank you, Your Honor.
So he is not coming back at 1:30?
No.
No.
And the same with,
And that other case too.
Planton also does not need to come back.
Yeah, plan.
Your Honor, this is Kendall Watkins. Let me just get my card.
Ms. Farkas, can I speak to you very briefly about this?
And then, and then, I think we're just a term. Oh, so there isn't.
Yep. Your Honor, I need to make an edit to this plea agreement, and there are quite a few cases. If we could just skip over him for 1 minute, and I can handwrite these edits in.
Okay.
I think that's my last line, so.
Yeah, that's about getting the.
Okay, so let me just do that and I'll leave.
Mr. Gates.
First up, we've got Ernest Gaucher, should be number 28 on the docket. We scheduled him for an early plea, Your Honor. So I may approach with the plea agreement.
You may.
Will be a score sheet, Your Honor. It's not an hour departure for this plea agreement.
Thank you. Would you announce?
Sure. Mr. Gaucher will be entering a plea of no contest to action charge. It's going to be adjudication of guilt of all counts. Counts 1 and 2, which are the felony counts. It will be 12 months of community control concurrent between the two. That will be followed by 24 months of probation concurrent between both counts. Waive the cost of supervision. Count 3, which is misdemeanor time served. 615 court costs, 150 public offender fee. No trespassing and cash liquor, located at 31 Beale Parkway, Fort Walton Beach, Florida, 32548. Restitution to Cash's Liquor in the amount of $1,286.33. Required to do a substance abuse evaluation within 30 days. Any recommended treatment within 60. Random urinalysis, 50 hours of community service work. Anti-theft course, which can be completed online. Maintain gainful employment or complete 3 job applications per week.
That is the state's agreement, Your Honor.
Your Honor, there's some property that was seized at his arrest. I've already talked with Fort Walton Beach Police Department. I got a list of it. Talked with the state. They're on board with returning it. I'm letting him review the order allowing the property to be returned. I'm going to file it here in a second.
Okay.
think we're good, Your Honor.
You good? So, Mr. Gaucher, if you raise your right hand, sir. You swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God.
Yes, sir.
So you heard your attorney state the terms of the plea agreement.
Yes, sir.
Pretty straightforward. You got 2 felonies and a third count, which is a misdemeanor. The misdemeanor is basically credit for time served with some costs and fees. And the 2 felony counts are 12 months community control followed by 24 months of probation. There's also a bunch of other requirements.
Yes, sir.
So no trespassing at caches, restitution to caches, substance abuse evaluation, recommended treatment, random UAs, 50 hours, anti-theft course, gainful employment. Long list. You prepared to do that list?
Yes,
everyone's waiting to sign that line to get out of the county jail. I understand that.
I'll be back in hand, yes, sir.
But you need to be, show up at probation and be ready to go to work. This ain't the beginning, because, they come back on community control. You know what they say. You get to the thing, then you get probation, then you get community control, and then the next thing, they be asking for prison, right? I don't want you to do. We got enough people. Got plenty of people to use those orange jumpsuits.
Yes, sir.
Okay. We want you to stay out.
Yeah,
You're going to have to be focused.
I got you.
You understand that? You understand that by entering this, you're waiving the right to go to a trial?
Yes, sir.
And some other constitutional rights. You've gone over all this with your attorney. You got a good attorney.
Yes, sir.
Explain this to you. And you're entering this voluntarily, I'm hoping?
Yes, sir.
Okay. Any questions?
No, sir.
Very good. Based upon that, there'll be an adjudication of guilt on all counts. 12 months community control, followed by 24 months probation on the 2 felony counts. Credit for time served on the misdemeanor count, plus all the other requirements that are subject to the probation. Any questions?
Waive the cost of supervision, Your Honor?
Yes, sir.
And then if I can approach with an order for the court. And Mr. Gaucher, if you have a week, the clerk's office should have a copy of that to get it and take that to full on each police department, okay? So back up, left to the clerk, okay? Yeah.
I assume the state's okay with this. I don't know if they need to sign off on it, but whatever.
No, I don't think.
Court's ordering it.
Yes, Your Honor. So it's about it. Yeah.
As long as you state as an officer of the court.
Yes, Your Honor. Ms. Sardina actually looked at the order right before I provided his.
That's correct.
Your Honor, this is going to be Mr. Jackson before the court, Keith Jojo Jackson. He's actually also on the 3:30 docket for a motion hearing.
Correct.
At this time, we're actually going to be entering a plea to negotiate a plea agreement in Mr. Jackson's cases. Based upon the plea, we will be canceling the hearing scheduled for this afternoon.
Okay.
So I may approach, Your Honor.
You may.
There'll be no score sheet on this one, Your Honor, because the state is reinstating supervision.
Okay.
And he's pleading to a misdemeanor and a new charge.
Would you announce the terms?
Yes, Your Honor. Mr. Jackson's before the court at 13 CF 24, 13 CF 25, 13 CF 39, and then 23 CF 2070. He'll be admitting the violations before the court in 3 2013 cases, pleading no contest to a lesser included count 1 offense of possession of paraphernalia. He'll be adjudicated guilty in all counts and cases. In all the VOP cases, it's going to be modification, reinstate, waive the supervision fees, assess a $100 cost of prosecution in each case, $150 public defender fee in one case, $100 public defender fee in the other 2 VOP cases required to complete the original requirements. And 23 CF 270, count 1, be 11 months, 29 days of probation concurrent, waive the cost of supervision, 270 court costs, 100 public defender fee, required to do 24 hours of community service work. Any outstanding requirements in this case will be rolled over into the VOP or the 2013 cases, Your Honor. And then the state's going to dismiss counts 2, 3, and 4 in exchange for a plea to the lesser included offense in count 1.
What's the lesser included on count 1?
Possession of paraphernalia, Your Honor.
That is the state's agreement, Your Honor.
Gotcha. I ain't even going to ask how you ended up getting this deal. Would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and I see those same terms are in the written agreement which you signed.
Yes, sir.
Just want to make sure you've gone over it with your attorney. I assume you have in detail. You understand what you're waiving the right to go to a trial and contest all this. You believe this is in your best interest?
Yes, sir.
I certainly understand why. You had all your legal questions answered.
Yes, sir.
Very good. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt on all counts. They're modify and reinstate probation on the 3 VOPs, 24, 25, and 39 cases. And then in the new law charge, 23 CF 270. Count 1 is going to be 11 months, 29 days probation. That'll run concurrent with your other probations. And then waive the cost of supervision, standard fees and costs, community service hours. The rest of the counts 2, 3, and 4, are all dismissed and rolled into it. Count 1 is actually a lesser included in possession of paraphernalia. Okay, any other questions?
No, sir.
Thank you.
All right. You know, this is going to be Jordan Kimmel before the court. Should be number 35 on the morning docket. The plea agreement to be filed with Mr. Kimmel's case, if I may approach, Your Honor.
Yes, sir. Thank you.
There will be no score sheet on this. Mr. Kimmel actually was sentenced to misdemeanor probation.
Do you know?
Yes, Your Honor. Mr. Kimmel is going to be entering an admission before the court at 23 CF 659. The adjudicated guilty, we're going to revoke and terminate his outstanding probation, sentence to credit for time served, $100 cost of prosecution, $150 defender fee. He'd ask for 24 months to pay those outstanding fees before they're sent to collections, and there'll be no action on the FTA associated with this case as well.
That is the state's agreement, Your Honor.
Mr. Kimmel, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard the terms of your plea agreement, pretty straightforward. I see you've signed the plea agreement with that in writing. Just want to make sure you understand you had all your legal questions answered by your attorney.
Yes, sir.
And you're waiving the right to go to a trial, so I just want to make sure you understand that. And you believe it's in your best interest to enter into this?
Yes, sir.
And you're entering it freely and voluntarily?
Yes, sir.
Based upon that, the court will accept your plea. There'll be an adjudication of guilt. Court will revoke and terminate supervision. You'll get credit for time served. That's actually the sentence. So you're done with your probation. You got the standard fees and costs. You have 24 months to pay it before it gets sent to collections, and the state agrees not to pursue the failure to appear. Any questions?
Well, I'll tell you, Steve, do you have the number for JCS probation? I do. There you go.
No, sir. Thank you.
Thank you.
We're going to bring Watkins back out, and then we're going to transfer the this type
Your Honor, Kendall Watkins is reapproaching. There are 8 dockets before you. 2017 CF 1907, 2017 CF 2064. They're all 17, so 2065, 2066, 2337, 2338, 2339, and 2819. They are all VOPs. The state and the defense have reached an agreement in these cases, if I may approach.
Mm-hmm.
Make sure it's all signed. Nope, my client has to sign it, sorry.
Okay.
Okay. Okay, if I may approach, Your Honor.
Thank you. Did you announce?
Yes, Your Honor. There was a previous adjudication of guilt on all charges. 2017 CF 1907. This is the only one that includes misdemeanor violations as well. Count 1, admit the VOP, revoke and terminate the current term of supervision, sentence to a new term of 2 years administrative probation, pay the remaining balance of restitution. And this term of probation will run concurrent with all the other counts and cases. Counts 2 and 3 will just admit VOP, revoke, and terminate supervision. All the other cases, it's the exact same sentence. In 2017 CF 2064, counts 1, 2, and 3, admit VOPs, revoke and terminate current supervision, sentence to a new term of 2 years administrative probation, pay the remaining balance of restitution. I'm not sure if the court would like me to read every single case. I'm happy to do it.
No, I mean, if they're identical, which I see
They are exactly identical. And I'll provide a copy to probation as well. And I'd like to put on the record that Mr. Watkins has been, he lives and works in Tennessee.
Georgia.
I'm sorry, Georgia. Why did I say Tennessee? In Georgia. And I let probation know he'll speak with them about it, but his brother is here. He's been living there for quite a while, so hopefully the transfer of probation is not a big issue.
Yeah,
Because
we don't deal exactly with the transfer, but they're pretty good. They know how to do that.
Yes, sir. Thank you, Your Honor.
Okay. State in agreement?
Yes, Your Honor, the state is in agreement.
Mr. Watkins, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So certainly I understand it's pretty straightforward transaction, and but I just want to meet. You do have the right to contest all this, to go to a hearing. You're waiving that right to get a final resolution. I believe that's in your best interest to do that.
Yes, Your Honor.
And you're entering in this freely and voluntarily.
Yes, Your Honor.
Have you had all your legal questions answered by your attorney regarding this plea agreement?
Yes, Your Honor.
Okay. Based upon all that, the court will accept your plea agreement, and on the misdemeanor, the 2 misdemeanor VOPs in 17 CF 1907, the court will on all these you're admitting the VOP, but there'll be a revoke and terminate supervision. Those will be done. In count 1 and all the other counts, which are the felony VOPs. And there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 of them. I'm not going to go through them. They're in writing, clearly laid out. In all of those, you're admitting the VOP again. And we're revoking and terminating supervision. So we're ending the old probation, and you're being sentenced to a new term of supervision. So a new term of probation for 2 years. This will be administrative probation in order to, and I assume a lot of it's based upon the continuing to pay the remaining balance of the restitution. And all these 13 cases will all run concurrent. So it's a total of 2 years administrative probation.
Yes, Your Honor.
Okay. Any questions?
No, Your Honor. Thank you.
Okay. Now, do we have some fees and costs in this? Are they always?
I forgot to write the fees and costs in, Your Honor.
Yeah, I mean, they're always want to get in your pocket for
Yes.
some more fees and costs.
Please.
So.
So I don't go through this.
Prosecution fee.
That's fine. We're complete. I just need to know anything else.
I assume that I'm required to add the fees for every case. Is that correct? Are we required to do that?
I believe so.
And also our original terms and conditions we imposed.
He's completed every single other term except for paying the restitution, so the state and the defense agreed that it's just the restitution,
So
any
the answer
balance.
is no. Not,
Yeah, I guess the short answer,
not all
I'm
the
sorry.
terms, just the term, the remaining term of restitution. That's essentially why they're extending it and putting it on administrative probation.
Sorry, Your Honor, I can make these edits. I don't want to hold the court up.
Okay, you're good.
Okay, I'll bring it back up
Okay.
once I add that.
Your Honor, this is going to be Kelsey Height, H-I-T-E, before the court. His height should be number 30 on the docket.
Got it?
At this time, Your Honor, we're going to enter denial on the VOP and ask to be scheduled without subpoena.
We'll deny the VOP on behalf of the defendant and continue this matter until 8:15 at 9 a.m. without subpoenas. What about Charles Johnson?
That's going to be, I can handle that, Your Honor. It's going to be with Ms. Vaso. Mr. Johnson was transported over from DOC last month. For whatever reason, he got transported back to DOC. So I've got to go through the process of getting him back from DOC to handle the DOC.
So to continue until 8:15?
If we can do a later date in August, I think we've got.
Sure, we can do August 20th or August 21st or September 12th.
Let's do August the 21st, Your Honor. That'll give me time to get an order together.
Now, we're doing that at 1:30 on those are only lengthier cases on the 21st. Is that like a regular?
I think that's your normal Thursday docket that you moved to Tuesday. Of course, I could be wrong, Your Honor. It could be the.
It's just got an asterisk that it's starting at 1:30. We have
We
three.
have church hall review in the morning, and so it's just a miscellaneous stuff in the afternoon.
So just we can do this short cases. Okay, we can do it in the 21st then.
Thank you, Your Honor.
Okay, thank you.
Your Honor, Steve Medina with Anthony Dwayne Allen. Mr. Allen's 27 on my docket for the morning.
Okay.
21 CF 282. He's before the court on a VOP. At this time, we're not able to work it out. He has a DOC offer. He was hoping to reinstate. We haven't worked that out at this time. He will deny the VOP. I do represent to the court that he appears to have serious medical issues that may be a burden to Okaloosa County taxpayers. He's going to be meeting with the jailhouse physician in the near future, and I may come back with some more information to the state. I'm hoping we can work something out, but at this time it's just denial.
Court will deny and we'll come back on the next date, available at 8:15.
Okay. Thank you.
Barn. Mr. Gates, we also have a Holcomb on, is that yours?
That's what Mr. Harper handled Mr. Holcomb earlier.
Okay, thank you.
Sorry, didn't mean to snatch. So you're going to go ahead and sign it? You ready to sign? Right there on that line. And I'm going to give you a copy saying the same thing. This is Delmos Barnes. Your Honor, Steve Medina before the court with Delmos L. Barnes. We have an agreement. I'm looking for the docket number, Your Honor. Court may find it before I do, I apologize.
Docket number, the case number is 22 CF 2031.
I had 22 CF 2235.
Yes, Your Honor.
Delmos Leon Barnes, docket number 40,
Okay,
22
yeah.
CF 2235.
You're right. Sorry.
Your Honor, I'm signing the agreement. It's been signed by the defendant and the state.
Your Honor, this is Ms. Passo's case, but I'll handle it for her.
And Your Honor, it is a reinstatement, so there is not a score sheet, but let me see if that was going to be I think it's probably a downward depart. A reinstatement, he would have been scored in prison, but it's a reinstatement, so it's not a downward departure technically. May I approach, Your Honor?
You may.
So there's not a score sheet at this time. Thank you. And officer, did I give you a copy?
Yes, sir.
Okay. Your Honor, at this time, Mr. Delmos L. Barnes has entered a violation of probation agreement under which he's admitting the violation. It's a copy for you. He's admitting the violation. He was previously adjudicated guilty. Reinstate and modify supervision to add 50 hours community service. He has to complete existing obligations. And we added an asterisk making it clear that the suspended sentence remains in effect. I believe it's a 5-year suspended sentence, so it's a very serious situation for him to comply. There's a $100 VOP fee. There would be 150 public defender fees. State agrees not to charge on the FTA.
State.
Your Honor, I spoke with Ms. Basso, and that she advised that this was the state's agreement.
Ms. Barnes, Mr. Barnes, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard the terms of the plea agreement. I see you've signed the written plea agreement. You gone over it with your attorney?
Yes, sir.
Had all your legal questions answered about it?
Yes, sir.
Importantly, you're waiving the right to go to a trial. You understand that.
Yes, sir.
This will be a final resolution of this violation of probation, so you're back on reinstating and modifying supervision. All you're doing is adding 50 additional hours of community service, of course the fees and costs. You understand that? So the suspended sentence is going to remain in effect. That's kind of like a sword hanging over your head, right?
Yes, sir.
But the way to avoid that is just day by day follow through on the probation, okay?
Yes, sir.
Stay in touch with it. So you understand that by entering this will be a final resolution in your case today.
Yes, sir.
And you're entering it freely and voluntarily.
Yes, sir.
Yes, sir.
And the state is, I think, agreeing not to pursue the FDA.
Yes.
I don't know if that was said.
It's on there.
Your Honor, may I I wanted to clarify one thing too. This is just to be, and me as an officer of the court with probation. Its recommendation also included he needed a strong reprimand, and I just was mentioning that the court is emphasizing the importance of it. So I don't know if the court wanted to state any more, but.
Well, the most obvious thing is the suspended sentence. I mean, when they come back, they don't come back and ask for a portion of the suspended sentence. They come back and ask for the full suspended sentence. And they could have done that technically on this violation. They could have done that. I don't know anything I can say should emphasize it more than your own freedom. So you can get out. We got enough people in jail. You need to stay out, but you need to abide by this and follow the terms of the probation, okay?
Yes, sir.
Any questions?
No, sir.
Thank you, Your Honor.
Okay, thank you.
Your Honor,
Yes, ma'am.
he's Jessica Lunsford. He will need GPS hooked up before he's released from jail.
That is correct. Thank you.
And that's part of its existing obligations.
Further on.
Your Honor, Steve Medina with Mr. James Robert Bergeron. His cases are 24 CF 404, 24 CF 1061, and there is also a new law case, another new law case that I think is on the afternoon docket, 24 CF 1184. And at this time, I have given some substantial input to the state. We don't have a resolution. I'm going to be having further communications with the state and meeting with him once I get all the discovery. We would like to enter not guilty pleas on all the new law, both the new law cases and a denial of the VOP.
Very good. The court will enter a not guilty plea on the new law charge. We'll come back on 8/14, and we'll run these VOPs along with them on, come back on 8/14. We'll enter a denial on those. Okay?
Yes, sir. Thank you. Yeah, he does not need to come back at 1:30. He's
That's
pled
correct.
not guilty on everything. Thank you. Your Honor, this is Joshua J. Boudreau before the court. We have a VOP agreement resolving. He's 43 on the docket. Joshua Joseph Anthony Boudreau, 22 CF 64. And Your Honor, this is was an underlying misdemeanor VOP supervised by JCS. The state signed the agreement. He's been over it with me. He's signing the agreement. So there is no score sheet, Your Honor. May I approach?
You may.
Your Honor, under the terms of the agreement, Mr. Boudreau in 22 CF 64, he's admitting the violation. He was previously adjudicated guilty on a lesser included offense misdemeanor, revoke and terminate supervision, credit for time served, waive non-monetary requirements, monetary requirements to collections. There was also a liquidated restitution amount that will go to civil lien, $50 VOP fee, $50 cost of prosecution, $150 public defender fees. The state agrees not to charge on the FTA.
State?
Your Honor, has to say something.
Mr. Boudreau, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard the terms of the agreement your attorney laid out. It's in here in the written.
Yes, sir.
Which you've signed. Just want to make sure you've had a chance to go over it with your attorney, make sure you had all your legal questions answered.
Yes, sir.
Understand you're waiving the right to go to a trial on this.
Yes, sir.
Believe this is in your best interest to enter into this plea agreement.
Yes, sir.
Based upon that, the court will accept your plea, previously adjudicated guilty on this charge. Court will revoke and terminate supervision. You will get credit for time served. That's technically your sentence. And then court will waive any non-monetary requirements. And then any monetary requirements will go to collections. Restitution go to a civil lien. The standard fees and costs. The state will not charge on the FTA. Okay?
Yes, sir.
Your Honor, just for the court's awareness, I discussed with him if he wanted some time to pay, but he owes a bunch of other monetaries, so he's just going to have to work on it all. When he gets out, he doesn't have a valid license right now. He's got to clear a bunch of stuff up.
Okay.
Thank you. Good day. Thank you. Your Honor, Steve Medina with Ahmad Rashad Braxton. He's 44 on the morning docket, and he's on the afternoon docket too. The morning docket cases were 24 CF 144 and 24 CF 154. The afternoon cases are 24 CF 1189 and 24 CF 1328. At this time, he would, I think he'd already entered a not guilty plea in the first two cases that are on the morning docket, and it was his status. So he will go ahead and enter a not guilty plea to the two remaining cases. So a not guilty plea's been entered on everything. We're working on a Phoenix House application. The cases have not been resolved, and I would ask for a next court date of all
We'll
cases.
come back with the standard pretrial and the underlying cases.
Yes, Your Honor.
We'll come back August 14th.
Okay.
Without subpoenas.
Yes, sir. Yes, so he doesn't need to be on the afternoon docket.
That's correct.
Okay. Mr. Brown? All right, Steve Medina, Your Honor, with Nathaniel Drew Brown. He's number 47 on the morning docket, 24 CF 387. And let me grab his file, Judge. I think he's also on the arraignment docket at 1:30 for 24 CF 1219. And so he had previously denied the VOP on June 13th. I would, just in case, I want to reiterate the denial in that case.
In what case?
24 CF 387.
Okay, that's
he
today's
already
case.
denied.
Okay, very
I'm
good.
just reiterating
Gotcha.
that denial.
Right.
And then in 24 CF 1219, it's on the afternoon docket. We will plead not guilty, have him be on August 14th. He is applying for treatment, but he is asking for a reinstatement, and the state is looking at that, but we don't have it worked out at this time. The state would really wants him to do treatment rather than a non-treatment deal, so we do not have a resolution. He's asked me to add to the list of facilities to look at, road to recovery, and I will get with this PD's investigator and see if we can pursue that application as well. And so we will see the court on August 14th.
Very good. So we'll continue both these cases until 8/14 and continue to pursue the treatment.
And Your Honor, when I get full discovery, I'll be in to see him. I know there's lots of things that he wanted to discuss. We're trying to get a felony knocked down to a misdemeanor and so forth that might help with Keaton and so forth. Thank you. Appreciate it.
Thank you.
Thank you, Your Honor. Thank you, sir.
Finish for the day.
Oh, okay.
Is that the morning docket on August 14th?
Yes,
sir.
Thank you.
Thank you, Judge.
He's done for today. He does not need to remain for the afternoon, sir.
Barry.
Right. You gotta set me up, man.
We'll bring her the afternoon. Well, she has an arraignment this afternoon anyway. What's that?
Don't hold her till the afternoon.
Okay.
Just as an.
Okay, Your Honor. Your Honor, Steve Medina with Victoria L. Berube. Ms. Berube is on the, I think she's on both dockets. We're going to go ahead and have her, she may be on the afternoon docket side, I'm not sure.
She is.
24 CF 965 and 24 CF 1296.
Correct.
She will enter she'd already done a not guilty in 24 CF 965. She'll go ahead and enter a not guilty plea in 24 CF 1296, and we can leave her on August 14. We're trying to work out a straight jail deal, and I'm optimistic that we will do so, Your Honor.
Very good. We'll continue both these matters until August 14th at 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
Good luck.
Alan, sorry, I skipped.
Okay.
Hello.
Your Honor.
Did I get on?
Your Honor, Steve Medina with Carson R. Allen. She's before the court in 22 CF 2031. Is there any way we could bring her back on July 16 or whatever the next VOP the next week is? Because I'm hoping we can work something out for her. It's the first VOP. There's some extenuating factors that I've been discussing with the state. I'd rather not hold her all the way to August.
Yes.
Thank you, Your Honor. Okay.
And what is today's date?
Today's the 11th.
16th of July, so it's next week.
Okay.
Okay, thank you, Your Honor. All right?
Mm-hmm.
Thank you.
All right, thank you.
Thank you. Thank you.
We'll be in the morning.
Patricia Brewer.
We're almost done here. Your Honor, Steve Medina with Patricia L. Brewer and 23 CF 2789. The court has ordered a competency evaluation for reasons I don't have the answer to. The order appointing Dr. Zeman didn't go to Dr. Zeman until I learned of that last week. And we sent it to him when we found that out. So he's going to be working on her competency evaluation. I'm not able to take any further action until we get that resolved. I know it's been...
When do we want to come back?
He just, last week got it. I think it's going to have to be August 15th or something like that.
Very good. We'll come back on August 15th. And
Your Honor, I have fired this man for the last 3 months. I do not want him to have anything to do with my medical HIV, my HIPAA. I have asked for another attorney. I wrote this court 3 different times asking for an attorney. My daughter...
I understand we need to get the evaluation done first.
I don't want him to have anything to do with my medical. If he talked to me, he would know I'm competent. But he has never sat down and listened to my side of what happened to me. Hey, how is he going to defend me that I'm innocent until proven guilty when he's never even heard what happened to me? How do you do that? And I've got the paperwork, Your Honor, that I paid the bill.
Thank you, Your Honor.
Scott.
Scam.
Your Honor, Steve Medina with Sky H. Brewer, 24 CF 641. I would ask for a August 15th control date. The state has agreed to have her evaluated for drug court. So hopefully she's going to be getting into drug court in the next, hopefully a couple weeks or so. If we could just put her on August 15th and she could come off that docket if she gets into drug court.
Very good. Court will continue this matter until August 15th.
Thank you.
Mr. Medina, I have one other defendant that's on my list that was out of custody is Tevin Austin.
Yes, Judge, I think that's an artifact.
That's 22 CF 15.
Yes, Judge, the VOP was dismissed.
Okay.
Back in, I think it was June 13th. I could be wrong on the date, but that should come off the docket, Your Honor.
Okay. Very good.
Yes, it was June, VOP dismissed. It's in the clerk's minute record on June 13th.
Very good. Okay.
Thank you.
Okay. So that's a wrap for this morning. So Mr. Gates, is unfortunately, you're here for the 12:30 and you're seeing where my morning docket is at. So I'm going to take at least a 15, warning you, at least a 15-minute break, but I'm going to take a short break. We'll come back, probably in about 20 minutes to try and we'll do the pretrial.
Thank you, sir.
Okay.